Number 91, the people of the state of New York versus JL. We'll just wait one moment until council excuse themselves.
Thank you, Your Honor.
Thank you. Okay, I will remind council to try to keep your voice up and stay close to the microphone so we can all hear you. Council?
Good morning, Your Honors. Cynthia Colt of Appellate Advocates on behalf of JL Appellant. Your Honor, I would also like, Your Honor, to reserve 2 minutes of rebuttal time.
Of course.
Thank you. Your Honors, this case stands for the very basic proposition that a trial court must instruct the jury on all material legal principles applicable to the case. In this case, voluntariness of constructive possession was a material legal principle. Whether appellant was aware of the existence of the recovered weapon long enough to have been able to terminate that possession.
Did you raise that issue in terms of how you presented your defense? There seems to be some, question about whether the defendant ever argued that he was aware at any time of the gun being there.
Your Honor, the appellant testified during his direct testimony that he was a recent arrival to the apartment, that he had never been in the back room where the weapon was recovered, so it wasn't his main defense, but he also testified after he was shot, he ran to the back room, he saw the weapon, he drew a picture of it. He called it something like the weapon. He drew a picture of it for a questioning detective. And then obviously the police were on the way, and he didn't testify to this, but he couldn't terminate his possession. Defense counsel specifically requested the charge applicable to those facts, that if appellant was aware of this weapon for long enough to have been able to terminate it, that's not voluntary. The trial court actually understood the point and said, oh, I understand what you're saying. And you can argue in your summation that his awareness was so fleeting that it didn't constitute voluntary constructive possession, but he did not argue that because that would have been an incredibly dangerous argument.
The judge thought that the charge overall was enough and was concerned that the requested charge would be confusing. Why wouldn't it be confusing?
Well, first of all, it's a very specific short charge saying just this, that a voluntary act includes the possession of property if the actor was aware of his physical possession or control, in this case we're talking about control, thereof for a sufficient period of time to have been able to terminate it. There doesn't seem to be anything on the face of it confusing, and it certainly wasn't confusing in conjunction with the rest of the charge, which instructed the jury that constructive possession was being aware of your possession and being able to have control over the area where the property is discovered. So I don't think it conflicted or confused any issues. And the jury was also charged...
Did the judge ever explain why it might be viewed as confusing?
He didn't explain it. To me, it seemed as though he thought it was confusing because the DA was confused about the charge. But he didn't further, he never said there's he did say there is a view of the evidence that supports this charge, but it's too confusing.
But the DA's confusion was based on, I may be wrong. You can clarify here. It appeared to me when I read this record that the DA was confused because the DA thought that the defense position was, I didn't see a gun, I don't know anything about a gun, I ran in to get this towel, and I ran out, and this is not my apartment. I just was there for a few hours.
I think that's true. That was how the DA interpreted defendant's testimony, appellant's testimony.
Is that the way counsel argued it to the jury? Putting aside this testimony, was that the way counsel argued it to the jury? My client never saw anything.
He argued it that he didn't possess the weapon because that's what the jury was charged with. He had to be very careful, because if he argued that, okay, he saw the gun, but it was so short that he wasn't able to terminate that possession, the jurors had no legal instructions on which they could consider that argument. So I think he sort of rode the fence, saying that there was no constructive possession. This was a kid who had just arrived there that night. It's not his guns, which obviously isn't the standard, but the DA also seemed to agree. We're not saying that these are his guns, Your Honor, but he was the one in the apartment. So the DA's thoroughly prosecuted him on a constructive possession.
So you're saying that the defense's argument was he doesn't have the kind of control over this space that gets it elevated to constructive possession under the law?
Yes, I think that's correct.
So he may, which I take it then the position is, and I'll ask your opposition here, it's not in conflict with a position that says he saw it, he knew it was there.
That's correct, because one, constructive possession is that you have control over the area in which the object is found. He clearly did have control over this area. He ran back to the area, saw it, was able to pick up a towel in the same area, so he obviously was able to either use or dispose of it in that short period of time.
As in with the towel?
Yes, as with the towel. But it was so fleeting, as the trial court understood, actually said, but you're arguing that his awareness of the weapon was so fleeting that it did not constitute constructive possession.
What about the effect of the mail with his name on it that's in the drawer with the gun? How does that suggest that it's fleeting?
Well, first of all, we have no idea when the gun or the mail was placed in the drawer. The gun was on top of the mail. So based on his testimony, he said that he had no idea that the gun was there before he was shot. And it was only once he ran to get the towel to help himself when he saw the gun at that point. So I don't think the presence of the mail really adds much either way.
Does the DNA add anything?
I don't think so, because the DNA expert testified, well, three police officers testified, first of all, that they saw blood on the gun, which supports appellant's testimony that he saw it when he ran back to get a towel. The DNA expert, although it seemed she didn't believe it was blood, she said she could not rule that out. She couldn't say when the DNA was placed on the gun, how it was placed on the gun, whether he touched the gun, or secondary transference, or if blood dripped on the gun. So I don't think the DNA either explains much or adds much to the case, because it could have happened when appellant said he momentarily saw the gun.
Thank you, counsel. Counsel?
You're welcome.
May it please the court, Dmitry Povajuk for the respondent. The court's instructions adequately conveyed the proper legal principles to the jury.
Counsel, can I give you a hypothetical?
Yes.
Okay, so I have constructive possession over my bedroom in my house, right? And I go to work in the morning, and I come back, and while I'm away, somebody plants a gun in my dresser. And I come home, and I go to change my clothes, and I open the dresser, and I see this gun, and the same time that happens, the doorbell rings, and it's the police. In that case, would I not be entitled to a voluntariness charge? Because I'm clearly in constructive possession, and I see the gun, I know it's there, but I don't have sufficient time to dispose of it properly.
Your Honor, I would push back a little bit on the assumption that there's constructive possession in that case. If you read the specific instruction that the court gave, or at least constructive possession in the way that the court instructed it to this jury, was that a person has tangible property in his or her constructive possession when that person has exercised a level of control over the area in which the property is found sufficient to give him or her the ability to use or dispose of that property. So this use or dispose of language essentially indicates that there has to be an exercise of constructive possession. It's not simply control over area, but it's the ability to dispose of the property that's within that area. For instance, if someone had soldered a firearm to your radiator, perhaps you're in constructive control of that space, but in no way do you have constructive possession of the gun itself.
But doesn't the instruction that you just read talk about the ability to exercise a level of control over the space, not over the objects in the space? My worry is that the instruction that was given would allow the jury to conclude the following. The defendant testified that he paid $100 to rent that room. That in and of itself gives him constructive possession of the room. And the payment, which is his undisputed testimony, plus finding a gun there without the voluntariness instruction, would allow the jury to convict simply because the gun was there and he paid $100 for the room.
I would say that conflicts a little bit with the wording of the instruction that was given in this case, which is specifically talks about the ability to use or dispose of the property. Well, I agree with Your Honor, and your point is well taken. The beginning of that instruction talks about the space. The qualifying issue there is the ability to dispose of the property. And I think that the way that the court instructed
that qualifies the level of control, not the actual disposition of the property. That is, in Judge Stein's example, if it's her bedroom, she has complete control over the property and to dispose of whatever's in it as regards her control of the space. And that's the way the instruction's framed.
But the question is that what the voluntariness charge adds is sufficient time, awareness for a sufficient period of time to be able to dispose of it, not whether you have the control over it to do so, but whether you have the time to do so.
Right, I take the court's point. I would just say one more thing on this issue, which is that the instruction with regards to constructive possession is not exclusive of time. If you read it literally, it says the ability to use or dispose of property, which contemplates whether or not you have the time to use or dispose of that property. So I would argue that that constructive possession is inclusive of the voluntariness charge.
Yeah, but that, as is already being said, that could be understood by a rational juror as I've got possession of the area, which means, of course, I could have gotten rid of that gun, as opposed to, as the law points out, a temporal aspect of possession.
Right, I agree with you, Your Honor, but I would also note that another way of looking at this case is I'm not sure that this is really a case of figuring out whether there's a possibility of an involuntary constructive possession, as the defendant suggests, which is a kind of a tenuous grasp because constructive possession suggests that you exercise some control over property. But the question here...
Well, of the area. That's the distinction that I think you're hearing members of the bench ask about.
Right, I understand. And what I would suggest is that the question here is whether that constructive possession is based off a voluntary act, because that's really what the statute that talks about voluntariness.
Let me try it a different way. So the judge says it will be confusing to give this charge. What makes it confusing to address the temporal element?
No, I agree, Your Honor. I don't think it necessarily would have been confusing in this case.
So then why isn't it an abuse?
Because
why isn't it error if it's not confusing, if that's an error by the court to think it's confusing as opposed to addressing an element that's not properly addressed by the remainder of the charge? We look at the charge in totality.
Right. So if the court is not buying the argument that the constructive possession charge is already inclusive of the voluntariness charge, the other argument, or one of the other two arguments, is that there's really no reasonable view of the evidence here. If the jury credits the defendant's testimony in this case, then the jury will acquit under this court's instruction because it would find that the defendant had never had any kind of relationship to this gun in such a way that he had exercised control over it.
Well, it seems that this jury did find him credible on some matters because they found him not guilty of some of the other charges. And, you know, couldn't it have made the difference if they were aware of this temporal thing? They said, okay, well, maybe then, I mean, they heard testimony in the trial about his drawing the picture of the gun, and so on and so forth. So they certainly could have said, well, you know, maybe he did see the gun, but he didn't have control over it long enough.
Well, I would argue that with respect to this particular gun, insofar as there is a substantive distinction between those two charges, there's no significant probability that the outcome would have been different had they heard this voluntariness charge, because the evidence was overwhelming here.
Well, they did ask for the instructions on possession knowingly and intent to be read back, right? So
They did, Your Honor, but I would note that, you know, sometimes jurors ask for instructions to be clarified, and sometimes they ask for the instructions to be read back or given to them, and in this case, they wanted the instructions themselves, and I think that that's slightly of a lower level of significance than had the jury come back and ask, can you please explain this to us? And once again, I just would like to point out just the corpus of evidence.
So what do you say is overwhelming? Because the DNA is questionable, right? Nobody saw anything. There was some corroboration to his testimony that he had been at his aunt's and he got this piece of mail at his aunt's house, and there was some corroboration of his testimony about this guy Paul, who, by the way, nobody seemingly bothered to look for. So what do you say makes the evidence so overwhelming here?
Well, first of all, the gun itself was, to begin with, in the room that the defendant was staying in. The gun was surrounded by pieces of mail that were addressed to the defendant.
Surrounded or on top of a piece of mail?
It was on top, but there was other pieces of mail. If you look at the exhibit that is a photo of the gun, there are other pieces of mail that are addressed to defendant. And
In the drawer? In the dresser drawer?
yes, I believe so, in the photograph. There isn't a clear photo. And forgive me if I'm
Okay,
misstating the record.
this I do want to make clear, so you're going to have to find your way on that record. Are you saying that the
I will say-
photo displays more than one piece of correspondence addressed to him under the gun, that there's several pieces? I don't know how that
Your Honor,
makes a
I
difference
stand
for
corrected.
the argument, but...
Your Honor, I stand corrected. From what I remember of the photograph, there is one piece of mail that clearly depicts the defendant's address. There are other pieces of mail, but I can't remember if there is any testimony about what addresses are on that mail. But that would tend to suggest that the defendant had interacted with that drawer, and that, you know, unless somebody had put the gun there after he had put the mail in, you know, the defendant's testimony was that he hadn't walked in there.
But aren't these factual issues that go to the jury, and that's not the law when it comes to deciding whether or not a charge should have been given?
Well, I think this court can still look at whether or not to give the charge was harmless, and once again, this is the lower significant probability standard.
But that's my point. There are different inferences to be drawn from that gun placed in that way on the mail.
So there's the gun, there's the DNA, which I would argue isn't as weak as this court suggests, because the officer who had taken the DNA from the gun testified that he would have seen blood on the swab that he was using. So whether or not there may have been blood on the gun, there was not blood on the particular pieces from where the officer was taking DNA from, as well as, you know, the defendant was he prevaricated about whether or not he saw a gun. He lied about his name. He lied
Well, those
about
are
where he
credibility
lived.
questions, are they not? Because he says he didn't do that.
Well, yes,
And
certainly.
again, are
but
we looking this in the light most favorable to him?
in terms of the charge, yes, but then in terms of the reasonable or the significant
But
possibility.
we've said conflicting evidence is not necessarily a basis for deciding that a charge cannot be given.
I agree with you, Your Honor, although I would note that there's some conflicting evidence and there's some evidence that's not. I mean, when you take the conflicting evidence in
Okay.
tandem with the evidence that's a little bit more objective, you have what we have here, which is, I would argue, overwhelming evidence. I see that my time is up.
Thank you, counsel.
Your Honor.
Counsel?
Just briefly, I would just like to pick up on that, the factual issues, just because, and in many cases, this court has held this, People v. Zona for one of them, just because the people now see factual issues in the case did not relieve the court from its responsibility to give the material legal instructions in this case. And to add to the argument about harmless error, the jury was, I think this absolutely made a difference. The jury was very concerned about what possession meant, what knowing meant, what intent was. And despite the prosecutor's arguments at trial in summation that appellant went back to the room precisely to pick the gun up and use it, the jury acquitted appellant of the intent to use this recovered gun. They also acquitted him of possessing the gun that was in the drawer in the kitchen. So they definitely had issues with this case, and a properly charged jury, I believe, would have acquitted Mr. J.L. of this charge.
Thank you, counsel.
Thank you, Your Honors.